have lined up. They have broken for the day. They will resume live testimony, and we will bring that to you tomorrow morning live, beginning at 9 a.m. In the meantime, this gives me a chance to talk to my guest about this case, and then in a moment, we're going to talk about that priest sexual misconduct case out of Massachusetts. But for now, you know, one of the emails that we've gotten about this case is the relevance of the testimony that we've seen over the last hour or two. That is, the FBI agents who went to the RV, gathered all of the evidence that was so painstakingly brought into evidence, as we've seen. And the emailers, like Wendell, say all this stuff about what happened in Woodland Park, Colorado, is just minutia. It only goes to befuddle and confuse this jury, whose only questions are going to be relative to the shooting and death of Officer Aubrey Hawkins. Does that make sense?
Prosecutors learn from O.J. Learn from the O.J. case. Don't over-try your case. Now, I'm not saying that the emailer is correct, because all these guns and everything that happened, even though this particular defendant was long gone, tends to show the violent nature of the escape and the violent nature of the group. The government can later on argue that, you know, the defendant in this case reasonably should have anticipated that a murder could have taken place outside the sporting goods store, which is a way for him to get convicted of capital murder, because these guys were so crazy and these guys were so violent. So in that regard, it is very material to the case.
Well, and I think you're right. And keep in mind, those of you who have been emailing me about that the prosecution doesn't have to put a gun in the hand of this defendant, doesn't have to show that a bullet came from a gun in his hand that killed Officer Aubrey Hawkins. Instead, there is a felony murder theory that Bob just alluded to, and that is, if they can show that he should have reasonably anticipated that being a part of that conspiracy, being a part of that robbery, that a murder could have resulted. And I think that's got to be the argument that the prosecutors are most heavily relying upon. There were so many guns, there were threats of violence, that the only possible conclusion could be that he would have reasonably anticipated that somebody could have been hurt or killed.
Believe it or not, that's their fallback argument. That's not their stronger argument, but that's a pretty heavy fallback argument to have. How could you not know that when all these guys are committing a robbery, that there might be a guard there and that guard might get killed? Okay, that's the fallback argument. The other argument is, if he helped, it's as simple as that. Did he help? Did he do a command? Did he say, hey guys, we better get out of here? Or did he say, this is the way we might go about doing this? But in his own words, if the jury believes that the defendant actually did confess, he had a gun and he fired the gun. Now, what was he doing out there? Was he just kind of going like he wanted to be a Mexican bandito, hi, you know, shooting it into the air, or was there a purpose to it? If there was a purpose to it, and if the jury believes the confession, then firing a gun could have just, all they would have to show and argue is that maybe it diverted the attention of the fallen officer for a second because he had to look at some other person.
That's a good argument. I haven't heard that one yet.
Well, hopefully they'll do this. I mean, you know, the government probably won't make that argument, but if the decedent's attention was diverted for a second just because another gunman was out there, that's enough to convict them of capital murder. So, you know, there are a lot of things, and you would think that the government would have told the jury this in the opening statement so the jury can understand why this is material, because, you know, the jurors are the people that have the power here, and it's very important not to leave them out. They need to be included in your discussions. They need to be included in every step of the trial. And if they're sitting in a box like this emailer is, saying, why the heck are they bringing this in? You haven't done your job.
Well, that's a very good response. Okay, let me give you another one, and this one's from Sharon on a different subject in the case, disagreeing with me. And Sharon, I think you make a good point. She says, you just stated that the defense attorneys in this case appear to be very good. I do not agree. They have repeatedly failed to object to the leading questions asked by the prosecutor. Today, they failed to object to the speculation offered by the witnesses. For the most part, I think the defense attorneys are sleeping with their eyes open through this trial. What's your take on that?
Maybe so. I mean, but there are a number of times that you actually can lead on direct. For example, a lot of the work that was going on today was foundational work, laying foundations for exhibits to come in. You're allowed to lead during that. Now, I do agree, this prosecutor is leading, you know, a lot. I mean, it's really quite extraordinary. But the one thing that the audience should understand is that jury studies tell us that when prosecutors lead witnesses, they're actually hurting their own case. They're actually hurting the witness.
Because jurors see through it?
Well, the jurors interpret it as being a lack of trust. In other words, they don't think that the prosecutors actually trust the witness to give the witness the reins to go out and testify, you know, freely and truthfully. So you may think that you're helping yourself, and this is what I teach the students, you know, up at the law school. You may think that you're helping yourself by leading the witness, but you're actually hurting your own case.
But that assumes that the jury is sophisticated enough to know, as I think probably most diligent court TV viewers know at this point, that the jury knows that on direct, you can't lead. On cross, you can lead. Because a lot of times people will say to me, isn't he leading the witness? And I'll say, yes, but it's cross-examination. I think the average person may not understand the distinction.
Well, except that when they interview these people for the jury studies, they're dealing with common jurors. They're dealing with people who don't have any more sophistication than the jurors in this case. And this is what the studies turn up, that jurors tend to, you know, doubt the credibility or doubt the ability of witnesses who have to be led in the courtroom.
Well,
so
you know, as you pointed out, you teach trial advocacy at Pace University. What would you say if the prosecutors in this case were before you? Would you have told them to tighten up the presentation that they did in the last few hours?
It's very hard to deal with this kind of evidence. What I would tell them is, I hope that in their opening statement, in his opening statement, he would have forewarned us. He would have told the jury, now look, this whole case is interesting, and it's escape, and it's murder, and whatnot. But let me tell you something. There are going to be times when you're going to want to take a gun and shoot me. It's going to be that boring. I am going to move 1,000 pieces of evidence into evidence. Those days you'll want to pull your hair out. It's going to be boring, but it's still important. And that way, when they get to this point of the trial, the jury says, okay, here's the boring part. Now, the fact is that they don't really have to pay close attention to this. And in summation,
I got to cut you off there. I'm sorry, but understand there's some action in the courtroom. There's a witness on the stand, but the jury is not present. Let's listen.
Yes, it is.